Something massive is happening in federal courtrooms across this country right now, and the odds are overwhelming that your local news is not covering it, and when they finally do get around to it, they are going to get it completely wrong. Gun owners across America are waking up to a fundamentally different legal landscape, and the vast majority of them have absolutely no idea it is happening beneath their feet. If you legally own a firearm, if you have been sitting on a permit application that a government bureaucrat has been sitting on for months, if you live in a state where some official in an office gets to decide whether your constitutional rights are sufficiently justified, what is unfolding in courts right now changes your situation dramatically. And there are critical mistakes being made by gun owners every single day during this transition that are still landing people in serious legal trouble, even as the legal ground shifts in their favor. I have gone through the court opinions, the legal filings, the post-ruling analysis from firearms attorneys, and the actual constitutional framework these courts are relying on. What you're about to hear is the clearest, most complete breakdown you're going to find because the mainstream media is either ignoring this entirely or mangling it beyond recognition. Hit that subscribe button right now, because when states start scrambling to rewrite their laws in response to these rulings, and they already are, you need to know the moment that happens. Do not be the one who finds out last. Here is everything you need to know. Let us start with the constitutional foundation, because without it you cannot understand why what is happening in courts right now is so significant. The Second Amendment states that the right to keep and bear arms shall not be infringed. For most of American history, courts played fast and loose with what the word infringed actually meant. States were allowed to impose virtually any restriction as long as they could argue it served public safety. Permits, waiting periods, discretionary denials, good cause requirements, training mandates, fees, all of it was layered on top of your constitutional right, and courts generally waved it through without serious scrutiny. Then came District of Columbia versus Heller in 2008. The Supreme Court ruled for the first time that the Second Amendment protects an individual right to keep a firearm in the home for self-defense. That was a genuinely monumental ruling, but it left enormous questions open, and anti-gun states exploited every single one of those gaps for 14 years, building an ever more elaborate architecture of bureaucratic obstruction designed to make exercising your rights as painful and expensive as possible. Then came New York State Rifle and Pistol Association versus Bruen in 2022, and this is where everything changed. In Bruen, the Supreme Court did not simply rule on New York's carry law. They threw out the entire two-step legal test that lower courts had been using to uphold gun restrictions for decades. Justice Thomas, writing for a 6-justice majority, established a completely new constitutional standard. A gun regulation is only valid if it is consistent with the historical tradition of firearm regulation in America at the time the Second Amendment was ratified. Read that again carefully. The government now has to prove that any gun restriction it wants to enforce has a direct historical analog going back to the founding era. Officials do not get to argue public safety statistics. They do not get to cite modern crime data. They have to show that in 1791, or close to it, a similar restriction existed and was broadly accepted by the American people. That is a seismic shift in constitutional law, and courts all over the country have been applying that Bruen standard, and permit systems have been losing badly. Here is what the most recent wave of court decisions has produced. Federal courts applying the Bruen test have found that discretionary permit systems, the ones where a government official decides whether you have good cause or a proper reason to carry a firearm, are unconstitutional. No historical analog exists. There is no founding-era tradition of government officials gatekeeping who gets to exercise a constitutional right based on their own subjective judgment. The may-issue permit system, which has existed in states like California, New York, New Jersey, Maryland, Massachusetts, Hawaii, Delaware, and Rhode Island, is collapsing under this standard in courtroom after courtroom. And the legal pressure does not stop there. Shall-issue systems, where the state is supposed to issue your permit if you meet objective criteria, are facing their own serious legal challenges. Courts are now asking the fundamental question, if carrying a firearm is a constitutional right, why does exercising that right require government permission in any form? That is the question that the entire permit infrastructure cannot answer under the Bruen framework, and states know it. Now let us get specific about the geographic impact, because this affects different states in very different ways, and understanding which category your state falls into is critical for knowing what you can legally do right now. 28 states have already enacted permitless carry laws. These are states including Alabama, Alaska, Arizona, Arkansas, Florida, Georgia, Idaho, Indiana, Iowa, Kansas, Kentucky, Louisiana, Maine, Mississippi, Missouri, Montana, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Dakota, Tennessee, Texas, West Virginia, and Wyoming, along with more recent additions. If you live in one of these states, the Bruen ruling reinforces and legally fortifies the framework you are already operating under. But here is what even residents of constitutional carry states are missing. Bruen also reshapes what restrictions states can impose on where and how you carry. The historical tradition test applies to location restrictions, magazine limits, and carry method restrictions as well. Courts in constitutional carry states are striking down location-specific prohibitions that have no founding-era precedent. Then there are the shall-issue states currently under serious legal challenge. Illinois, Colorado, Michigan, Virginia, Washington, Oregon, Minnesota, Nevada, New Mexico, Connecticut, and others. In every single one of these states, active litigation under the Bruen standard is directly challenging the permit infrastructure. Courts applying Bruen are asking one question: show me the historical tradition for requiring a citizen to ask government permission, pay a fee, wait weeks or months, and complete state-mandated courses before exercising a constitutional right. The states cannot answer that question. They are losing these cases. And then there are the remaining may-issue holdouts: California, New York, New Jersey, Maryland, Massachusetts, Hawaii, Delaware, and Rhode Island. These were the states where a police chief or local official could simply decide you did not have good enough reasons to carry, and there was almost nothing you could do about it. Bruen was directly aimed at New York's system and found it unconstitutional. The ripple effect across all remaining may-issue states has been immediate. California rewrote its carry law after Bruen and immediately got sued again. New Jersey's Attorney General issued new guidance, then faced federal court challenges. Maryland's system is under active litigation. Hawaii lost at the Ninth Circuit level. Let that sink in. The Ninth Circuit, historically the most hostile federal appeals court for gun rights in the country, ruled against Hawaii on a Bruen challenge. What has changed is not that all permits everywhere are suddenly void and unenforceable tomorrow morning. What has changed is that the constitutional floor beneath the entire permit system has been pulled out, and the legal demolition is happening in real time. Now here is the part that matters most practically, and this is where most commentary on this topic fails gun owners completely. Legal victories in courts do not automatically change what local law enforcement will do when they encounter you on the street. Getting this wrong is how law-abiding gun owners end up facing serious criminal charges even as they stand on the right side of constitutional history. Let me be direct about something important. What follows is educational information about the evolving legal landscape. It is not legal advice. Your specific situation, your specific state, and your specific circumstances require a qualified firearms attorney. What you're getting here is the framework to understand what is happening, not a green light to make specific decisions without professional guidance. Here is what courts are increasingly holding qualified citizens can do. In states where courts have struck down discretionary permit requirements, you can carry a concealed firearm in public without first obtaining a permit, provided you are not a prohibited person under federal or state law. The Bruen standard is being applied to hold that a qualified citizen's right to carry for self-defense cannot be conditioned on government approval when no historical tradition supports that conditioning. In shall-issue states where courts have stayed enforcement of certain permit requirements, qualified citizens can carry while litigation proceeds, depending on the specific terms of the injunction in place. In constitutional carry states, the Bruen framework continues to expand rights against location-specific and manner of carry restrictions. Here is what has not changed, and what will get you arrested regardless of any court ruling anywhere in the country. First, if you are a prohibited person, a convicted felon, a domestic violence misdemeanant, someone under a restraining order, someone adjudicated as mentally ill, no court ruling anywhere helps you. Possessing a firearm as a prohibited person is a federal crime, period, and these rulings do not touch that. Second, federal gun-free zones. Federal buildings, courthouses, post offices, airport secure areas, military installations. These are federal restrictions, and no state court ruling touches them under any circumstances. Third, private property. A business owner, a landlord, a venue operator can prohibit firearms on their premises. Ignoring posted no firearms signs can mean criminal trespass charges, regardless of what is happening in the courts. Fourth, state law prohibited locations that survive constitutional scrutiny. Even under Bruen, courts have found that some sensitive place restrictions are historically grounded. Actual school buildings, government meeting rooms, polling places on election day, these restrictions are surviving legal challenge in most jurisdictions. Fifth, interstate travel. If you are driving from a constitutional carry state through a may-issue state, the laws of that may-issue state apply to you while you are in it, unless a specific court order has enjoined enforcement. This is where gun owners get into the most serious trouble. Research every single state on your route before traveling with a firearm. Sixth, do not assume local compliance with court rulings. Some state and local law enforcement agencies are continuing to enforce permit requirements and are waiting to be sued. Knowing the constitutional argument does not protect you on the street in the moment. Comply calmly in the moment. fight it legally afterward. The critical legal standard to understand is this. Under Bruen, if you are a law-abiding citizen, meaning you can legally purchase a handgun after a standard background check, the constitutional presumption is that you have the right to carry that firearm for self-defense. The government must overcome that presumption. They must prove a historical tradition justifying any restriction they want to impose. Before Bruen, the burden was on you to prove your right. After Bruen, the burden is on the government to prove their restriction. That is a fundamental reversal of the constitutional burden of proof, and that reversal is what is dismantling permit systems in courtroom after courtroom. Understanding where this goes from here is crucial, because the legal battle is not over. It is accelerating. The next 12 to 18 months are going to see more rapid changes in gun law than any comparable period since Heller in 2008. Right now, multiple circuit courts are applying the Bruen standard to challenges against permit requirements, waiting periods, training mandates, and location restrictions. The outcomes are not uniform. Different circuits are interpreting Bruen's historical tradition test in different ways, which means conflicting rulings across the country. Those conflicts are exactly what the Supreme Court steps in to resolve. The Ninth Circuit, covering California, Oregon, Washington, Nevada, Arizona, and others, has issued a series of decisions applying Bruen inconsistently. Some panels are striking down restrictions aggressively. Others are attempting to find historical analogs that the Supreme Court majority almost certainly did not intend to allow. This kind of inconsistency at the circuit level is precisely what generates Supreme Court review. Legal analysts tracking the court's conference calendar are watching for the court to grant certiorari on one or more of the cases creating circuit splits on post-Bruen gun restrictions. When the court agrees to hear a case, the legal landscape shifts again. Lower courts begin staying enforcement of challenged laws while they wait for guidance from above. Based on the Bruen opinion itself, legal scholars across the political spectrum are reading Justice Thomas's historical tradition test as nearly fatal to discretionary permit systems. Shall-issue systems face a harder but serious challenge. A final ruling that directly addresses whether permit requirements violate the Second Amendment would be the most significant gun rights decision in American history. More consequential even than Heller or Bruen themselves, because it would directly govern what every American can do in public every single day. Here's what you also need to understand about the anti-gun states and their response. They know they cannot win on the constitutional merits before this court, so they are shifting strategies. If they can no longer condition your carry rights on a permit process, they will attempt to redefine where you can carry, flooding the zone with new sensitive place designations. Expect legislative pushes to classify public transit, restaurants that serve alcohol, public parks, sidewalks near schools, and commercial businesses as restricted zones by default, flipping the presumption so that carrying almost anywhere becomes legally precarious. Watch for mandatory storage requirements designed to create impossible compliance burdens, and financial liability mandates structured as catch-22s. These are the tools of a losing side trying to control the terms of their loss. Watch what those state legislatures do over the next 6 months, because their actions tell you more about where gun law is headed than anything the mainstream media will report. Now let us talk about the mistakes that are landing legal gun owners in serious jeopardy right now during this transitional period. Because the Bruen revolution is real and its direction is clear. But right now, in this specific moment, there are specific errors that are costing people enormously. The first mistake is treating a court ruling in another state as protection in your state. A federal court ruling striking down a permit requirement in California does not protect you if you are carrying in New York. Every court ruling has a geographic scope. It applies in the jurisdiction where it was issued. Know which rulings apply in your specific state and city before making any decisions. The second mistake is assuming a stay applies without verifying it. When a court issues a stay of enforcement, it means the government cannot enforce that specific law during the stay period. But stays are sometimes partial, sometimes appealed and modified, sometimes lifted. A stay that was in effect last week may have been modified this week. Verify the current status of any relevant stay before relying on it. The third mistake is carrying in a prohibited location because you believe the restriction is unconstitutional. Here is the brutal reality. You can be completely correct that a location restriction is unconstitutional under Bruen and still be arrested, charged, and convicted, while courts take years to resolve the question. Your constitutional argument is a legal defense. It is not a shield against arrest. Law enforcement enforces current statute. Courts decide constitutionality. These are two entirely separate processes that run on completely different timelines. The fourth mistake is relying on social media or internet commentary, including anything you hear here, as a substitute for current legal guidance. Gun law is changing faster right now than it has in decades. A ruling from last week may have been stayed, a stay may have been lifted, a law struck down may have been replaced by emergency legislation. For current, specific, jurisdiction-specific guidance, you need a licensed firearms attorney in your state. That is not a hedge, that is the reality of this moment. The fifth mistake is underestimating how hostile some jurisdictions will be during this transition. There are major American cities where local law enforcement and prosecutors are ideologically opposed to expanded carry rights and are actively looking for legal angles to charge carriers. Even where underlying permit requirements have been stayed, related ordinances and disorderly conduct statutes are being used in defiant jurisdictions against carriers. Know your local enforcement environment. Have a firearms attorney's number in your phone before you need it, not after. The sixth mistake is neglecting training because it is no longer legally required in your state. Mandatory government training requirements may have no constitutional basis under the historical tradition test, but correct and smart are two different things entirely. Carrying a firearm without training is not illegal in constitutional carry states. It is, however, dangerous, and it is legally risky in the aftermath of any defensive encounter. A trained carrier who can demonstrate proficiency and knowledge of use of force law is in a fundamentally stronger legal position than an untrained one. Get trained, not because the government can make you, but because it is the right call for you, your family, and anyone around you. Now let us deal with the mainstream media's handling of this story, because the pattern of coverage is itself something every gun owner needs to understand. Open any major newspaper or cable news site and look at how they are covering the post-Bruen legal landscape. If they are covering it at all, and many outlets are not, you will find stories focused on political controversy rather than legal substance. You will find framing that treats every court victory for gun rights as a public safety emergency rather than constitutional adjudication. You will see headlines reading, "Court strikes down gun safety measure," when the accurate headline would be, "Court finds permit requirement has no historical basis in American law." You will find crime statistics inserted into legal stories with no analytical connection, because the goal is emotional reaction, not legal understanding. Here is what they are not telling you. 28 states already have permitless carry, covering roughly 45% of the American population. The catastrophic predictions made when each of those states enacted constitutional carry did not materialize. They are not comparing crime statistics across constitutional carry and permit requirement states, because that comparison does not produce the narrative they are invested in. They are not telling you that the permit system has historically functioned as a mechanism for discriminating against lower-income citizens. A wealthy person in a may-issue state can afford a lawyer to navigate the permit process, afford the fees, afford the time for the required courses. A single working parent in a high-crime neighborhood cannot. The Bruen ruling benefits the people the mainstream media claims most to care about. It equalizes access to constitutional rights across economic lines. They are also not telling you that the Bruen majority opinion is a rigorous piece of constitutional scholarship, a deeply researched historical analysis, not a partisan document. The methodology of grounding rights in historical tradition is the same methodology that has been applied across constitutional contexts. The legal community's debate about Bruen concerns the method's consistent application, not whether it is outside the legal mainstream. Watch for these specific framing moves when you see mainstream coverage. Court allows anyone to carry. False framing, because prohibited persons remain prohibited and the background check requirement is untouched. End of all gun regulation. False framing, because the Bruen test explicitly preserves historically grounded regulations. Dangerous activist court. Opinion substituted wholesale for legal analysis. These framings exist because accurate coverage of this story requires admitting that major institutions were wrong about the constitutional question for decades, and that admission is one very few institutions are prepared to make. Here is exactly what every gun owner in America should do right now, given this specific legal moment. First, know your legal status. Are you a prohibited person? If there is any ambiguity in your history, any prior conviction, any domestic incident, any involuntary mental health hold, any restraining order anywhere, talk to an attorney before you carry anything, anywhere. The Bruen ruling does not touch prohibited person status. Federal law on prohibited persons is unchanged and aggressively enforced. Second, research your specific state's current legal posture. Is your state under an active court injunction against permit enforcement? Has your state enacted constitutional carry? Is your state in active litigation where the outcome remains uncertain? The Firearms Policy Coalition, the Second Amendment Foundation, and Gun Owners of America all publish current state-by-state legal trackers. Use them. The answer to these questions tells you exactly what framework you are operating under. Third, get trained voluntarily and aggressively. Find a certified instructor and take a carry course that covers not just safe handling, but use of force law in your state, de-escalation, situational awareness, and post-incident protocol. If you are ever involved in a defensive gun use, the question of whether you were trained will come up. Answer it correctly before the situation ever arises. Fourth, get legal coverage. The U.S. CCA, CCW SAFE, and Second Call Defense are among the major options. These are legal defense membership programs that provide access to attorneys in the immediate aftermath of a defensive gun use, when the decisions made in the first hours can determine your legal fate for years to come. The right time to get coverage is before you ever need it. Fifth, no use of force law in your state cold. Knowing that you can carry legally is the beginning, not the end. You need to understand what constitutes legally justifiable use of force where you live. Does your state have a stand your ground provision or a duty to retreat? What is the legal standard for reasonable fear of imminent serious bodily harm? What are you required to do or prohibited from doing after a defensive encounter? These are not academic questions. They are the difference between going home and going to prison. Sixth, if you are stopped by law enforcement in a jurisdiction where a permit requirement has been legally enjoined, comply fully in the moment. Do not resist. Document everything afterward. Date, time, officer identification, what was said, what was demanded. Contact a firearms attorney immediately. Enforcement of an enjoined law can constitute civil rights violations and is exactly the kind of case that firearms rights organizations are actively looking to litigate. Seventh, stay informed as this develops. The legal landscape is going to change multiple times in the next 12 months. Circuit court rulings, Supreme Court certiorari decisions, emergency stays, state legislative responses. Each development matters directly for what you can legally do. Subscribe now and turn on notifications, because when a major development happens in this legal story, you need to know immediately, not a week later after the damage is done. Here is the bottom line. The Bruen decision fundamentally changed the constitutional framework for evaluating every gun regulation in America. The historical tradition test it established is being applied in courts across the country right now, and discretionary permit systems are losing. Shall-issue systems face serious ongoing challenge. The legal direction is unmistakable. Before Bruen, the default legal position was you cannot carry unless the government grants you explicit permission. After Bruen, the default is shifting to you have the right to carry unless you are specifically and constitutionally prohibited. That is not a small procedural shift. That is a fundamental restructuring of the relationship between the government and the citizen on the question of self-defense rights outside the home. That restructuring is happening right now in real time in federal courtrooms across this country, and it is happening faster than any mainstream media outlet is prepared to honestly report. The permit system collapsing under the Bruen standard is the biggest gun rights legal story in a generation, and the gun owners who benefit from this moment will be the ones who stay informed, stay trained, stay legally protected, and understand exactly where the law stands in their specific jurisdiction today. Share this with every gun owner you know, because this story is not over. It is just getting started.